what the necessary steps are, so the careful review of its preparatory work will be needed to interpret, in accordance with 1969 VCLT, the Vienna Convention on the Law of the Treaty. Let me focus today on 3 points: the right to interfere with warships, 2 legal nature of necessary steps, and exception to immunity of sovereign vessels, such as warships and Coast Guard vessels. Let's see one by one. First, in the debate of ILC, International Law Commission, in 1955, the question arose whether coastal state could, in law and a matter of the principle, forbid the passage of warships in its territorial sea. The answer to the question was divided, but there was a broad consensus, or general consensus, that coastal states do have the right to interfere with the warships, regardless of the innocence. The disagreement was over the condition which such interference was justified. Second, there are 2 key aspects of the necessary steps that a coastal state may take. One focuses on security, especially military threat, and the other on law enforcement, ensuring compliance with the coastal state's law and regulations. When examining the discussion from the 1958 Conference on the Law of the Sea, this distinction becomes clear. Some delegations, like the US, views the test of innocence through the lens of military security. He said, the word security had no exact or precise meaning, but considered that it should be regarded as implying there should be no military or other threat to the sovereignty of the coastal state. It did not regard the word security as relating to economic or ideological security. Case was noting the test of innocence was only defined in terms of security, specifically military security at this stage. There was no other element. Meanwhile, as I addressed, the test of innocence should cover more than just military security. For this issue, the Indian delegation proposed ending the word peace, good order, or, which are drawn from the criminal jurisdiction of the coastal state. 2 tests of immunity, 2 tests of innocence to cover matter beyond military security. So it is reasonable to assume that while the term security primarily referred to military aspects, the newly added word peace and good order indicate a focus on law enforcement. There are these 2 distinct natures were clearly shown in the necessary steps in the 1955 6-part proposal. I will not delve into here, but if you are interested, please feel free to ask for it. Third, Article 32 of UNCLOS grants immunity to warships, and government vessels operate for non-commercial purposes, but it also recognizes exception to this immunity. The question then becomes, which article of UNCLOS qualify as this exception? Considering the immunity and exception were adopted in 1958 to reconcile the civil and criminal jurisdiction of the coastal state over government ships, the word exception could only be relevant to the article related to law enforcement, except for right of the protection of the coastal state. However, the nature of law enforcement doesn't match, because UNCLOS does not accept any prescriptive jurisdiction over security in the territorial sea. So theoretically, without prescriptive jurisdiction, there is no enforcement jurisdiction. Additionally, any coastal state response to foreign warships can generally be regarded as a matter of national security for the coastal state. So it's difficult to see articles related to law enforcement and UNCLOS as falling under the exception. This view aligns with the chairman's statement at the Third United Nations Conference on the Law of the Sea in 1982. In this regard, although some scholars argue without any reservation that Article 25 is an exception under Article 32, such argument is inaccurate because Article 25 thus has a law enforcement nature. Only the nature of security embedded in Article 25, Paragraph 1 qualified as an exception to the immunity to sovereign vessels. Let me conclude. In order to respond to the given case appropriately, the action of the coastal state must be flexible and proportionate. In other words, coastal state action should be on a case-by-case basis. UNCLOS doesn't clearly specify whether the coastal state can take forceful measure against sovereign vessels in the territorial sea, but it also doesn't deny such action. When analyzing Article 25 of UNCLOS in accordance with PCLT, it's reasonable to assume, as one of the ILC members from the UK pointed out clearly, the provision included all measures that was necessary to protect the coastal state. Given the nature of security, there is no room to interpret the provision as allowing the coastal state to take forceful measures against sovereign vessels as an exception to their immunity. In this sense, at least as far as the territorial sea is concerned, UNCLOS still works in light of the recent strategic and technological development. From a deterrence perspective, interpreting Article 25 in this way would be work, because it could reduce provocative action in the long term, enhancing regional stability. I will stop here. Thank you so much for listening.
Thank you very much, Dr. Hirano. I now pass the floor to Attorney Frederick Anchun, Senior State Counsel, Department of Justice of the Philippines.
Thank you, Your Excellency, for the introduction. And I would like to, before I start, I would like to take this opportunity to thank the Diplomatic Academy of Vietnam for the invitation to participate in this conference. The first time that I participated in this conference was in 2009, a long time ago as a junior lawyer. And now the conference is already in its 17th iteration, so congratulations to the Diplomatic Academy of Vietnam, and it's an honor to participate in this 17th conference as one of the panelists. I don't have presentation slides, but what I'm going to do is that I'm going to read the substantive part of my paper submission to the organizing committee in order to keep it within the 10-minute time that was given to me. And the title of my presentation, I also adjusted it to the theme of the session. And the title of my oral presentation is UNCLOS as the Constitution of the Oceans and Anchor of Maritime Stability. And before I start, because I'm a government officer, I have to make a disclaimer. The views that I express here are my own, unless expressly specified to be the views of the government of the Republic of the Philippines. And so, to start, I would like to say that the exclusive economic zone of the Philippines is not like the exclusive economic zone or EEZ of other countries in the world. You cannot find an EEZ like the Philippines. And I'm not talking about the natural resources that you can find in this EEZ, but of course, the EEZ of the Philippines can be considered special because it forms part of the world's coral triangle, and the Philippines is considered as the center of the marine biodiversity of the world. The EEZ of the Philippines is not like the EEZ of other countries because it is the location of more than 100 maritime features that are the subject of conflicting sovereignty claims by several coastal states, and several of these maritime features are physically occupied by foreign states in the EEZ of the Philippines, and of those occupied, some have been transformed into massive artificial islands fortified with military infrastructure. Of the foreign powers in occupation of several maritime features in the exclusive economic zone of the Philippines, it is China that has physically and coercively interfered with the exercise by the Philippines with Its interference in the Philippine EEZ can be traced back to 1995 when structures were placed on top of Mischief Reef, a low tide elevation that is only about 125 nautical miles from the Philippine archipelagic baselines, and therefore its waters form part of the Philippine EEZ, and its submerged land area forms part of the continental shelf of the Philippines. The reef was eventually transformed into a massive artificial island, about 550 hectares in size. There's also interference with the exercise by the Philippines of its sovereign rights in its continental shelf. For example, way back in March of 2011 at the Reed Bank, Chinese government vessels conducted aggressive maneuvers against a Philippine-authorized seismic survey vessel by steering head-on as if to ram the Philippine-authorized seismic survey vessel, then turning away at the last minute. This was way back in March of 2011. Reed Bank is a totally submerged feature that is about 90 nautical miles from the Philippine archipelagic baselines and therefore forms part of the continental shelf of the Philippines. Also, since 2012, Filipino fisherfolk were prevented from continuing their traditional fishing activities at Scarborough Shoal because of the presence therein of Chinese government vessels physically blocking the entrance to the lagoon of the shoal and utilizing water cannons to drive away these fisherfolk when they tried to return in 2014. Water cannons were used already way back in 2014. Moreover, since 2012, the Chinese government issued fishing ban in the South China Sea, includes the waters of Scarborough Shoal and the EEZ of the Philippines. These incidents and other related matters led to the filing by the Philippines of an arbitration case against China on 22 January 2013. To be sure, the dispute between China and the Philippines encompasses both territorial and maritime issues, as they both claim sovereignty over Scarborough Shoal, and together with Vietnam and Malaysia, they also claim sovereignty over the Spratly Islands. However, this does not mean that recourse cannot be had to the dispute settlement procedures under UNCLOS for the resolution of the maritime aspect of the dispute. This is what the Philippines did in 2013. It presented 15 submissions to the arbitral tribunal for resolution, and none of these submissions involved territorial issues, only issues on the maritime entitlements of the maritime features in its EEZ and the legality of the so-called 9-line of China, which encroaches on almost 90% of the EEZ of the Philippines in the South China Sea. The Philippines was able to initiate the arbitration proceedings against China because of the compulsory nature of dispute settlement under Article 286 of UNCLOS. Under Article 287, Paragraph 3 of UNCLOS, the default compulsory dispute settlement procedure is arbitration. Just by being a state party to UNCLOS, China has already given its advance consent to compulsory arbitration. And just to be clear, under Article 298 of UNCLOS, the issues on the maritime entitlements of the maritime features located in the Philippine EEZ, for example, whether they are islands entitled to generate an exclusive economic zone and continental shelf that would overlap with the EEZ and continental shelf of the Philippines, measured from its archipelagic baselines, and the compatibility to UNCLOS of claims to historic rights by state parties thereto, are issues that are not excludable from compulsory arbitration under Article 298 of UNCLOS. Without the compulsory dispute settlement procedures under UNCLOS, the Philippines would not have obtained an authoritative clarification of its maritime entitlements on the western side of the Philippine archipelago in the South China Sea. Because of the outcome of the arbitration under UNCLOS, it is now clear that there are no overlapping exclusive economic zones and continental shelves between China and the Philippines within 200 nautical miles from the archipelagic baselines of the Philippines in the South China Sea. With this clarification brought about by the arbitration under UNCLOS, all activities by the Philippines in the exercise of its sovereign rights in its EEZ and continental shelf are legally protected under UNCLOS, while all activities by China which seek to prevent or interfere in the exercise of this right, including the traditional fishing rights of Filipino fisherfolk in Scarborough Shoal, continue and will forever remain to be illegal under international law. It is in this sense that UNCLOS provided strong legal protection to the Philippines and brought stability to the Philippine position regarding its EEZ and continental shelf in the South China Sea. The non-compliance of the other state with the arbitral award issued under UNCLOS does not affect the nature of UNCLOS as the constitution of the oceans and an anchor of maritime stability. Its provisions on maritime zones, maritime delimitation, regime of violence, navigational rights, among others, reflect customary international law which are binding on all states, not just on the state parties to the convention. The provisions of UNCLOS bring stability to the maritime world, while it is the non-compliance or deliberate violation of its provisions that brings instability to this world. It might be useful to recall the history of UNCLOS, which shows that it was negotiated and concluded in order to primarily address the rising trend of unilateralism and excessive maritime claims by various states in the 1960s and 70s, founded on the idea that to have the law one wishes, all one need to do is to claim what one wishes and try to avoid judicial review. Accordingly, the international conference that drafted the convention exerted all efforts on the basis of consensus to come up with a comprehensive and integrated text that is meant to withstand the test of time, capable of addressing all issues relating to the law of the sea, and includes a compulsory system of dispute settlement. Both China and the Philippines attended this conference and participated in the drafting of the United Nations Convention on the Law of the Sea. The Philippines ratified the convention in 1984, while China ratified it in 1996. Since both states are parties to UNCLOS, it is a reasonable expectation that they both comply with their obligations as provided in the convention pursuant to the fundamental international law principle of pacta sunt servanda. In international law, as in domestic law, rights and duties go hand in hand. It is considered legally impermissible to claim rights under UNCLOS without being willing to assume the correlative obligations provided therein, such as compliance with an arbitral award issued under UNCLOS. Will UNCLOS stand the test of time? Are there gaps in UNCLOS because of the emergence of autonomous technologies such as maritime autonomous vehicles, especially maritime autonomous vehicles used for military purposes? Just like in domestic constitutions, the provisions of UNCLOS may be considered as providing only general principles and framework drafted in the 1970s. UNCLOS is not expected to contain specific provisions on maritime autonomous vehicles, hence a more specific convention or set of guidelines would need to be crafted. Pending the crafting of a specific convention or guidelines on the matter, UNCLOS can guide state practice and how to deal with maritime autonomous vehicles, particularly its provisions on nationality of ships, status of ships, duties of the flag state, immunity of warships and ships used only in government non-commercial services, and state responsibility for damage caused by warships and other ships used only in government non-commercial service. So yes, UNCLOS can serve as a guide in the interregnum, being the constitution of the ocean. This ends my oral presentation. Thank you so much for listening.
Thank you very much, Attorney Anchun. And let me pass the floor to Dr. Chris Rolwing-Tukun, Assistant Professor, Thammasat University, Thailand. The floor is yours.
Okay, thanks very much. And good afternoon, everyone. I'd like to thank Diplomatic Academy of Vietnam for inviting me and giving me this very good opportunity to speak before this distinguished international audience. So my topic about today is UNCLOS's framework for maritime stability, managing overlapping maritime claims between Thailand and Cambodia. Let me start by saying that what I'm about to share today reflects my personal academic views only, not the official positions of the Thai government or any institution or institution that I'm affiliated with. So when I first received the invitations to speak on this topic, I asked myself, how can I meaningfully contribute to this session? I decided to focus on overlapping maritime claims between Thailand and Cambodia, a case that, in my view, speaks directly to the issues of maritime stability. Although the area in question lies in the Gulf of Thailand, okay, rather than the South China Sea, it is connected to it, as you know. As many of you know, we look beyond, if you look beyond zonal approach established by UNCLOS, divisions by UNCLOS, these waters are really interconnected, really part of the same continuous sea. That is why I believe maritime stability in the Gulf of Thailand is closely linked to peace and stability across our region. Many of you might have seen this picture before. Okay. The orange shades of the area represents an undelimited maritime area between Thailand and Cambodia, an area where both countries have overlapping claims in the continental shelf. Right? This area believed to be rich in natural resources, oil and gas, and so on, which could one day become a vital source of energy for both countries. The origin of the overlapping claims dates back to 1972, when Cambodia unilaterally declared its continental shelf boundary. The following year, okay, in 1973, Thailand issues its own declaration, right, claiming that, oh, this is our continental shelf too. I will not go into the very details of the legal validities of either line, okay, because it's quite complicated. What matters here is that both countries rely on different legal and technical methods for drawing their boundaries, okay? As a result, an overlapping maritime area emerged. Okay, and in 2001, both sides recognized the need to manage this situation constructively. And for the first time, this led to the signing of the Memorandum of Understanding between two countries. An important first step in acknowledging the existence of different claims and agreeing to cooperate in a peaceful and orderly manner in order to manage this kind of undelimited maritime area. The MOU is contained a representations of identifying two key areas, as you probably have seen this before. One for future delimitation and another designated for joint development. And as you know, Cambodia has signed but not yet ratified UNCLOS, right? While Thailand is a party, still the spirit of convention guides our cooperation. Why? Because MOU reflects what Article 74 paragraph 3 and 83 paragraph 3 of UNCLOS envisage that a pending final delimitation states should make every effort to enter into a provisional arrangement, right, of practical nature. Both sides established a joint technical committee and agreed that any future boundary should be based on applicable principles of international law. Okay. However, the process has been slow, and after 24 years, and now after, we still not achieved what we hoped to do and what we hope to get. So in recent months, Thailand and Cambodia have experienced several clashes along parts of the land boundary, causing suffering to people in both countries. Our long-standing friendship and brotherhood that we have tried to build for several decades deteriorate because of nationalism, which of course deeply undermines our friendship. People on both sides could no longer look each other in the eye because of fake news, so many influencers in Thailand, and as a scholar, I am deeply concerned about how we can rebuild trust and preserve the spirit of good neighborliness between Thailand and Cambodia. Fortunately, the situation has eased following the joint declaration by Prime Minister of Cambodia and the Prime Minister of Thailand in Kuala Lumpur, thanks to Malaysia and the US. It was a positive sign that political goodwill still prevail. Okay, in Thailand, there has been public debate over whether this MOU should be revoked. Some fears that it undermines national interests or may result in territorial loss. Personally, I find this concern difficult to understand and absurd, as the MOU clearly states that it is without prejudice to the maritime claims of either party. In other words, it doesn't harm or limits anyone's rights. Yet some voices have even proposed holding of what we call a national referendum to decide whether to cancel it or not, which in my opinion is not the right approach for a matter as complex and technical as this. You might have heard that we are going to have a kind of referendum asking people whether or not we still this MOU. Yeah. Certain politicians and some group of lawyers with extreme nationalism, with hostilities towards our neighbor, want to do exactly that. And my argument here is straightforward. MOU is not a weakness. MOU is a strength. It is an instrument that embodies the cooperative philosophy of UNCLOS. I have tried to communicate this point to the public in Thailand, but it's still been debated, this issue. Even though Cambodia has not yet ratified the convention, it has the obligation not to undermine the objects and purpose of UNCLOS as a signing party, and more importantly, to negotiate in good faith. That is the obligation which is embodied in the customary international law. Even if Cambodia is not bound by a treaty's obligation, I can argue that it has to make every effort to enter into provisional arrangements. It is still bound by the rules of customary international law. So both parties must therefore avoid kind of adopting an unyielding attitude or unreasonable negotiating position. And in my opinion, abandoning the MOU would mean stepping away from that basic of duty to cooperate, to neglect the fundamental duties, and would open the door to unilateral claims. Just imagine what would happen if each side were to act on its own. That is a very, very dangerous situation. The absence of a framework for managing relations would be extremely dangerous, I would say. To maintain the MOU is to uphold the rule-based system, the system that we have long relied upon in managing our relations, and that we have consistently promoted in addressing maritime issues in the South China Sea. So as to avoid a selective interpretation, reinforces the importance of peaceful, law-based cooperation. And finally, I hope that our two countries will not remain trapped by the colonial legacy left behind, the maps that have caused us to quarrel. But we will, instead seek to a joint way forward through dialogue. Okay, personally, however, I would not rule out the possibilities of seeking ASEAN's assistance as a facilitator, as long as both countries continue to adhere to the principle of international law. That is always hope. Thanks very much.
Thank you very much, Dr. Wangui-Tukun. And now the final speaker on our panel, Mr. Chan Hu-Sui-Ming, Vice Dean, Faculty of International Law from the Diplomatic Academy of Vietnam. Thank you.
Thank you, Ambassador Robert. My first words are that it is my great honor to have a chance to present some of my personal thoughts report on the Law Sea Convention in this great forum where I listen to beautiful ideas and beautiful arguments from scholars around the world. The topic for my presentation is about the obligation of due regard under the Law Sea Convention and the South China Seas. As you may know that under the Law Sea Convention, the ocean and the sea around the world are divided into various maritime zones. And in the most of the maritime zones, no state has the whole right to the exclusion of other states. For example, on the screen you can see that in the territorial sea, the coastal state has sovereignty, but the other state has the right of in-ocean passage. And it's the same logic with the exclusive economic zone. The coastal state has some rights, and the other state has have some rights. In the high seas, no state has exclusive rights. All states have the same freedom. And when states exercise rights over the same maritime zone, conflict, incident may occur. Therefore, the convention introduced what one scholar called a conflict avoidance mechanism. The convention introduced the obligation of due regard, trying to guide states when they exercise their right on the same maritime zone, not to conflict with each other. For example, in the exclusive economic zone, we have two provisions, Article 56, Paragraph 2 and Article 58, Paragraph 3. In these two provisions, it provides for mutual due regard, where the coastal state shall have due regard to the rights of other states, and the other state shall have due regard to the rights of the coastal state. In the high sea, the same logic. This freedom of the high sea shall be exercised by all states with due regard to the interests of other states. And the question is that in the contiguous zone and the continental shelf, there is no explicit provision in the convention providing that states shall have due regard in these two maritime zones. But in my view, and supported by jurisprudence of the International Court and Tribunal, there is no reason why the application of due regard is not applicable to the contiguous zone and the continental shelf. My conclusion is that the obligation of due regard has a broad scope of application. It's applied to the vast area of oceans and sea around the world, including in the South China Sea. And it's also applicable to the overlapping area. I will go back to the South China Sea situation later. And what is the content of the obligation? If we read about the obligation of due regard, the key word is balance. The obligation requires the state to balance the exercise of their right with the rights of other states. That's in the spirit, trying to balance, trying to harmonize the activities of all states in the same maritime zone. But if I stop here, it's not really clear on how we can apply the obligation of due regard in practice. How to balance, how to do the exercise balancing activities between states. Luckily that we have some guidance from case law, and I will focus on one case, the Cargo Marine Protected Area case, in which in the award granted by the tribunal in 2015, three important points mentioned by the tribunal. First of all, the tribunal said that if a state implement the obligation of due regard, it is not enough just to taking note of the rights of others, not just acknowledge the rights of others. Something more needs to be done in order to fulfill the obligation of due regard. And the tribunal suggests that several factors should be taken into consideration. The nature of the rights, the importance of the rights of all the state, that these rights may be relevant for particular activities that one state wishes to conduct in particular area. The second factor is the extent of impairment. Is there any potential impairment from one state activity to the rise of other state, and the nature and importance of the activity that one state plans to do? And the final, very important, that the tribunal suggests that one state should look into whether there are alternative approaches available for them. Rather than do one type of activity, we can do the other type of activity with less risk of impairing the rights of others. That's the list of factors, and I believe that the list is not exhaustive. There are other factors that may be relevant to be taken into consideration. And the final point, and the clearest point that the tribunal observed, is that in majority of cases, the state will necessarily involve at least some consultation with the rights holding state. This means that consultation is the best way to comply with the obligation of due regard. And I will move to the South China Sea. I think that people are familiar with the situation in the South China Sea. I will not go into detail of the maritime claim. I just know some important features of the situation in the South China Sea. The main legal regime of the South China Sea is exclusive economic zone, or continental shelf, or the high seas. And if you see on the map, in the middle of the South China Sea, we have an area of the high seas, and the other areas are the exclusive economic zone and the continental shelf of the coastal states surrounding the South China Sea. And in the South China Sea, we observe that there are competing and overlapping maritime claims to exclusive economic zone and extending continental shelf, the continental shelf beyond 200 nautical miles. And in that, in the sea, we have the involvement of regional and extra-regional states. And I remember yesterday, Dr. Moon said that we should not talk about regional and extra-regional. And I agree to a certain extent to that point. And in the South China Sea, we also see that incident between states, both regional state and extra-regional state, happens. And in that context, when a number of states exercise rights in the same area of maritime zone, it calls for the application of due regard. And in law, I think that legally consultation is desirable, and often, as the tribunal in the Kairos case said, necessary. It's legally necessary, and factors subjective in case law should be taken into consideration by state seriously. In practice, good news is that we have consultation between several states concerned. We have the negotiation on the code of conduct. This is the way that state 11 ASEAN member states and China try to share, exchange their view, exchange their position, and try to make a balanced compromise on how to harmonize their activity and to not impair the rights of the other. That's the good news. And whether the CFC can be successfully concluded is beyond the scope of obligation of due regard. This obligation is the obligation of conduct. It requires the state to do something. It does not impose a result on the state. But in practice, some questions remain. First of all, because other states, extra-regional states, the Japan, South Korea, Australia, European states, they have the right in the South China Sea. They have the freedom of navigation, freedom of overfly, freedom of laying of submarine cables and pylons. There should be consultation with those states also. And yesterday we hear about raison d'etre. It raises the question of good faith and legal compliance. And my final point is that how we can guarantee that state comply with the obligation of due regard. How we can guarantee that the state shall have indeed due regard to the rights of people study of other states. Legal action, some people have talked about. I will focus on the second point. I think that the region needs institutionalized cancer. Lesson from the DOC. The DOC, if you read the DOC, is only substantive obligation. State will do something, but it's not a regional monitoring bodies. And I think that the COC should have some institutional provision to monitor or even to enforce the COC. And thank you, I will stop here.
Thank you very much, Mr. Ding. Thank all of our panelists. We now have 30 minutes for questions, so let me open up the floor for questions. If you could give your name and organization before you ask the question.
Thank you, Your Excellency. I'm Soham Agarwal from the National Maritime Foundation, India. My question is primarily directed to Attorney General, but I will be happy to hear views of other panels on the question. Ma'am, do you not believe that more emphasis should be given than currently is on securing compliance with the IMO conventions, particularly COLREX, which is the International Convention on Prevention of Collision at Sea, which applies to all vessels on the high seas, and even perhaps the SUA Convention, to address the navigational challenges and the aggressive coercive behavior in the West Philippine Sea? And also in the same breath, you mentioned that there are emerging challenges that the law needs to adapt to. So do you not believe that the committees within the IMO can be leveraged to develop new normative or expand on existing normative frameworks even within UNCLOS? Thank you.
Thank you. Take a couple of questions. You understood that one, Dr. Mitchell? Let's take another question up the back, I think.
Thank you so much. Frances Sangadi from the Australian National Centre of Ocean Resources and Security. Thank you so much to the panel for really fascinating observations today. Two quick questions, if I may. Firstly to Professor Lay. Really fantastic that you highlighted the important clarification of the ICJ regarding cooperation obligations. I'm interested if you have any thoughts on what that cooperation could look like. Now it is in the hands of governments to consider how to implement those obligations that the court has clarified. So really curious for your thoughts on what that might be. My second question is to Dr. Hirano. Thank you for posing that hypothetical as to protective actions a coastal state could take in respect of non-innocent sovereign immune vessels. I had a question about if you have made any observations on state practice in that regard, what coastal states have done in interpreting what they consider to be necessary measures permitted under Article 25, and if that maybe then might align with your observations on the historical debate. Thank you.
Thanks very much. I might, let's talk about three questions there. We might answer those first and then we'll come to you next. Dr. Ganshun, do you want to answer that first question?
Thank you, Your Excellency, and thank you for the question regarding the International Convention on Preventing Collisions at Sea, or COLREX, which is an instrument under the International Maritime Organization. Yes, the Philippines consider that the dangerous maneuvers and all of those aggressive actions in the West Philippine Sea. And by the way, I'll take this opportunity to make a clarification regarding the West Philippine Sea. The West Philippine Sea just refers to the waters under the jurisdiction of the Philippines. It does not refer to the entire ocean. So it refers to the waters up to 200 nautical miles from the archipelagic baselines of the Philippines, including the territorial sea of the maritime features that the Philippines consider to be part of its national territory. Now, with respect to COLREX, yes, all of these dangerous maneuvers, etc., are considered also not just a violation of UNCLOS, but a violation of COLREX. And it is explained in the arbitral award that if you violate COLREX, you also violate Article 94 of UNCLOS, because Article 94 of UNCLOS entitled duties of the flag state. The flag state has the duty to ensure that its vessels do not conduct these dangerous maneuvers, etc. But if, of course, these are state-sanctioned dangerous maneuvers, the is to violate directly Article 94 of UNCLOS. And so, yes, the IMO instruments can also be considered in managing the situation in the West Philippines. Thank you.
Thank you very much, Professor Lee.
Thank you for the question. I think the UNFCCC and of course has made a very concrete cooperation obligations, especially for the climate change issues. But there's a very important principle of the called CBDRC under the UNFCCC legal framework. And ICJ made it very clarify to the two ends of this spectrum of states. Right? One is industrialized state, the other is the least developed states. And the obligations for the industrialized states is very clear. They have the obligation to transfer their technologies, to offer financial supports. But one thing remains uncertain is that how about the obligations for the states in the middle? I mean, the states between the industrialized states and developing and least developed state. And this is a very typical question poses to some emerging powers just like China, Indonesia, Brazil. It has a very strong strong need to develop, and then they also have the capacity, more capacity than the least developed countries. And I think that China has led a very good practice in this area. Although China emphasizes it or identifies itself as a developing country right now, but China is trying to offer more. Right? China states that since 2016, it offers about 177 billion Chinese dollars, Chinese army, to the South cooperation. So I think considering the South China Sea and most of the countries are developing countries, I think China could do more to cooperate with adaptation measures and mitigation measures such as the green energy transfer and something the energy transition, some of the issues, and there's lots of practice that China could cooperate with the ASEAN member states in the South China Sea. Thank you.
Dr. Hirata.
Thank you very much. It's a very right question and reasoned question. Simple answer is no. I can't find any state practice against warships and coastal vessels based on Article 25, Paragraph 1. In that sense, my theory is just theoretical view.
Thank you. Ms. Tek, yes. Gentleman in the middle.
I'm from Anna University of Natural Resources and Environment. I have two questions, and the first question is directed to Professor Xiaolu. In fact, you said that the UNCLOS is a constitution of the oceans, and I would like to add that the 2016 arbitration award is contribute for the interpretation of the UNCLOS. So, according to the award, the U-shaped line has no legal base. I understand that Chinese government and scholars in China have difficulty when explain that the U-shaped line is unlawful. So, do you think that the award provide you with opportunities to tell Chinese people that our claim is unlawful and you should drop the unlawful maritime claim? And the second question I would like to direct to Professor Lei Xiaolu and Dr. Hirano. And in fact, in South China Sea, we have barely and coercive actions. And that is by the Chinese Coast Guard against the ships from other countries operating lawfully in their respective EEZ. So, do you think that is the tactics of the Chinese government to force coastal states to recognize their unlawful maritime claim of the U-shaped line or foreshore or something like that? Thank you very much.
Thank you. We had a question over on the right-hand side. Yes.
Thank you. My name is Nitya. I'm one of the young leaders this year. This question is for Mr. Min. You brought up the Chagos Archipelago case as an example of how UNCLOS works and its relationship to the South China Sea, but the Chagos Archipelago dispute is quite famous for the fact that there's been repeated international opinions, and yet the UK, the US, and Mauritius as stakeholders haven't really complied to international opinion. So the dispute has been resolved at a sort of bilateral level, but still has issues with compliance with international human rights law. So I was curious if you could explain the case a little bit better. Why is this a good example for the South China Sea?
Thank you very much. So let's start. The first question, I think, was for you. Did I misunderstood? Who was the first question to?
All right, it's about the award. Yeah. And the 9-9. Yes, there's a very comprehensive discussion by the Arbitral Tribunal on the illegality of the 9-9 by China. And yes, I took note of what was stated yesterday, that it originally appeared as 11 dashes officially in the map that was issued by the Department of Boundary of the Ministry of Interior of the Republic of China in 1948. And there's a map there in the award of the 9 dashes. It's called, of the 11 dashes, it's called the 9-9 because the map that was eventually submitted by the People's Republic of China to the United Nations Secretary General in 2009 shows 9 dashes. So that's why it's called 9-9. But in the 2023 standard map of China, it's now 10 dashes. Some people would now call it the 10-9. It has no basis in international law. That is right. The tribunal actually invalidated it not just on the basis of the provisions of UNCLOS, but it also took into consideration customary international law, because there's a provision in UNCLOS that says that the tribunal, in resolving the disputes brought before it, can use not just the provisions of the convention, but also other rules of international law, which would include customary international law. So first, the compatibility of this 9-9 with the provisions of UNCLOS. We know UNCLOS is considered as the constitution of the oceans. It provides for a comprehensive legal framework of the maritime entitlements and responsibilities of coastal states, as well as the rights and duties of other states with respect to the use of the seas and the oceans. It's very comprehensive, and there's nothing there that says that historic rights can prevail over sovereign rights of a coastal state in its exclusive economic zone and continental shelf. The very nature of sovereign rights in the EEZ is not compatible with historic rights to the natural resources that is being used by China to claim all of the resources inside this so-called 9-9, that all of the fishes inside there belong to it, that all the oil and gas that can be extracted inside the line belong to it. So historic rights is incompatible with sovereign rights under UNCLOS, and so therefore, when China became a party to UNCLOS in 1996, any historic rights claim that it may have had were superseded by the provisions of the convention. But the tribunal did not stop there, because the tribunal actually used also customary international law, and the tribunal explained that under customary international law, for historic rights to form, you must be exercising a right that is not allowed under international law, but you proceeded to exercise it anyway, and through a long historical course, because nobody objected to your exercise of that right, through the acquiescence of other states, historic rights have formed in your favor. And according to the tribunal, the exercise of freedom of the high seas in the South China Sea, because it's a freedom that is allowed under UNCLOS, cannot give rise to historic rights because it does not entail the acquiescence of other states, because it's already a right allowed under international law. So there's also customary, assuming that it can claim historic rights. The court proceeded to explain under customary international law, there must be evidence that you have actually historically prevented nationals of other states to fish in that area, that you've regulated fishing in that area, but there's no evidence that through long historical course, China has historically prevented or regulated fishing of other nationals in the South China Sea, and the state of these nationals acquiesced to the exercise of this regulation by China. So it's a very comprehensive discussion on the illegality of 9-9, and we hope that China aligns its actions with respect to the award and the illegality of this 9-9. Maybe it can be interpreted because I understand, reinterpreted because I understand that when it originally appeared in the Republic of China's maps, it's not meant to claim all of the waters, just the relevant waters around the maritime features being claimed by the Chiang Kai-shek government. So thank you.
Thank you. So the second question, Chinese Coast Guard reactions, I think, for you, Professor Lei and Dr. Harada.
Thank you, Excellency. And I just mentioned about the constitution of the ocean, right? But everybody knows that it's a metaphor, because if you think there is a real constitution, it's like in the domestic law, in the international level, that's impossible, right? So all the international law based on the state consensus, and UNCLOS is a treaty between the states. But it really has some very important role in the global governance, because it has some fundamental values and principles on the law of the sea. So that's the basic point. And you're talking about the 2016 Arbitral Tribunal's award. Well, I think why China opposed that kind of award is already published in its website. And I think you can go through the official position on this issue. But here I'd like to share some personal points of view on that tribunal, that award, a little bit. First of all, I cannot agree with the tribunal is that I think lots of the issues are really relating to the sovereignty. Just taking the Scarborough Shoal example. Just now we mentioned about the traditional fishing in the Scarborough Shoal, but actually, if we're talking about the traditional fishing of the fishermen, we're relating to that issue to who owns the Scarborough Shoal first. I know that the tribunal used a kind of approach that to make a premise that this Scarborough Shoal belongs to China and the Philippines is the other country. Then the Philippine fishermen will have traditional fishing in that area. I'm not commenting whether it's right or wrong here, but the approach itself has a premise that China is a sovereign over the Huangyandao, Scarborough Shoal. The approach itself indicates that the sovereign issue is not irrelevant. It's very important to decide whether the Philippine fisherman has the traditional fishing rights or not. So in many of the cases, I think that it indeed relating to the sovereign issues. I just mentioned that UNCLOS cannot deal with the sovereignty issues, especially for the territorial sovereignty over that maritime features. And secondly, I think the arbitral board does not do very well in interpreting some very important provisions of the convention. For example, the Article 121 of the convention. It's hardly to say that it considers the state practice all over the world appropriately, because according to the standards given by the arbitral tribunal, lots of the islands claims are illegal. for example, the Okinawa to rocks in the Pacific Ocean. If we applied the standards of the arbitral tribunal to that small isolate, maybe it cannot reach to be an island, but Japanese government claimed 200 nautical miles for that little isolate, and even the continental shelf beyond 200 nautical miles. So I'd like to say some of the interpretations on the very core provisions of the clauses not very well in that arbitral tribunal, and that really matters. It not only matters for the merits, but also matters for the jurisdictional issues. Because if Taiping Island, Itu-Aba, is an island according to the normal standard of the Article 121, then the tribunal must not have jurisdiction of majority of the submissions of the Philippines. So that's my very personal view on this issue. And talking about the EU-shaped line, I think there's no 10-shaped line notions, I think. Because in the very beginning, there were 11 dashed lines in the South China Sea. And the other sector is on the east side of Taiwan. So if you see, I think the Chinese government just do minus, because it's 11 dashed line in the South China Sea, and then when we have a conclusion with the Vietnam in the Tonkin Gulf, we made that delimitation. The two sectors has been eliminated, is erased from the map. So there's remains 9 dash line in the South China Sea. The other one is in the east of Taiwan. So there's never considered 10 dash line issue here. And I think that the historical rights, China has not clarified what kind of historical rights in the 9 dash line, but there's one thing concerns that China argues all the maritime features within that line, the sovereignty of the maritime features as the 4 groups of islands. So China's territorial claims is not based on every single maritime features, but taken the spratlys and parasols and Dongshan, this is just like the 4 groups of islands as a whole. So that's the basic claims for China. So I'd like to say that this arbitral board dealing with something it has no jurisdiction to deal with. So that's my understanding about the arbitral board and the UNCLOS. Thank you.
Thank you. Dr. Hirano.
So what I can say here is legality is needed to take action, to conduct any activity, to support operations. My conclusion is just focus on the territorial sea. Comparatively speaking, beyond the territorial sea, I still don't find any legality under UNCLOS. So it could be natural. Bigger nations tend to rely on the already capability aspect, but not to become a threat, we need more careful study for the legality. Thank you.
Thank you. And Mr. Min, the Chagos follow-up question.
For the questions about the Carlos MBA case and how it's relevant to the South China Sea, you have several points. The first point is that you are right that the two cases, they are totally different. It's related to different areas, it's related to different states. The second point is that even if they are different cases, in legal theories, we can pick the legal reasonings and interpretation in one case and then apply to the other case. That's what we call case law. And the third point is that in the South China Sea arbitration, when the tribunal in that case between the Philippines and China trying to interpret the obligation of geopolitical, the tribunal did make a reference to the CARPOS cases. So my answer is that we can learn something from the past cases, and the reasoning, the interpretation may be a useful guideline for how we can understand the application of geopolitical in other circumstances, even in the South China Sea. That's my answer.
Thank you very much. We've got a number of questions on the screen, and I noticed, I think we've got time for one more. Dr. Wong-Wei-Tung, there's one to you. You haven't had a question yet. The question is, given that Asian culture generally has a preference for amicable settlement, i.e. negotiations, what approach should ASEAN take towards the de-judicialization strategy, which might have implications for ASEAN countries' leverage on their maritime claims?
Okay, thanks very much for the question. I think my answer would not address just only about the problem between Thailand and Cambodia, but I'd like to answer as in a general terms. I think there's various ways which ASEAN can learn of how to settle dispute between disputing parties. Dejudicialization is very good keyword here. I think we should learn from the case between Australia and Timor-Leste, where conciliation commissions is used, in the sense that this is not just only about legal issues that we talk about. We need to take into consideration several factors, historical background of the disputes, economic factors, and something like that. Because the origin of disputes in each case is totally different from one another. So if you would like to settle a dispute between Thailand and Cambodia, you need to know about our long history from the ancient time. You need to take into account the economic factors. So who can do this function? Who can consider this function? Court is not an appropriate way to go, because it's just a court of law, and they just interpret legal texts, provisions, which is very hard way to settle the dispute. And the outcome of the dispute settlement process is the lose-lose situation. It's not a win-win situation, I think. ASEAN might consider the way in which they can act as the mediators, conciliators, or even fact fighters or something like that. So I personally would like to, or would like to support or encourage ASEAN to study about the conciliation process. It covers a lot of things. Fact finding is one of the functions of the conciliation commissions. Not just about the interpret law, apply the laws, but they can, cite this also the way in which we can find a fact. Because sometimes the disputes arise because of they disagree about the fact, what really happened on the ground. So that is the reason why we need to look the other way, is an alternative way to settle the dispute. In our own way, as suggested by these questions, ASEAN culture generally has a preference for amicable settlement, that is negotiations. Conciliation is kind of hybrid nature. It's kind of a non-judicial means of dispute settlement mixed with the judicial means of dispute settlement. So that is my answer, that ASEAN might learn experience of Australian and Timor-Leste.
Thank you very much. I think that's a great way to end this session on a positive example of where UNCLOS and dispute settlement resolutions were used. Can I ask everyone to, I think I have to draw to a conclusion. Yes, 3 o'clock, yeah. There is a time constraint on us, but can I thank everybody? Could you all join with me in thanking And I think you get a coffee break now, so thank you.
Yes, thank you very much to all. all speakers and participants for reaffirming the importance of law and cooperation. Now, please take a short coffee break before our final session begins at 3:15 p.m. Please make sure to complete our post-conference survey, and your feedback is always highly appreciated. Thank you.